This is Bankruptcy on Tape with the memorandum opinion regarding which debtor entities have liability for customer claims under the terms of use in the Celsius bankruptcy. Martin Glenn, Chief United States Bankruptcy Judge, writes, "Do customers, as defined below, have claims against the debtors and all of their affiliates, or only against Celsius Network LLC under the terms of use? This is a difficult gating question. Careless drafting of the terms of use leaves the answer unclear. On one side, the debtors, the 11 entities that filed Chapter 11 petitions in this court, and the official committee of unsecured creditors, urge the court to find that the customers have claims against each of the debtors and each of their non-debtor affiliates. Together, the debtors and their non-debtor affiliates will be known as the company. On the other side, Community First Partners LLC, Celsius SPV Investors LP, Celsius New SPC Investors LP, and CDP Investments Inc., collectively the Series B Preferred Shareholders, urge the court to find that customers only have claims against the LLC. The Series B preferred holders are not parties to the terms of use. However, because they made significant investments in Celsius Network Limited, or CNL, the top-level parent company, and their investment contracts did not prohibit CNL and its affiliates, other than the LLC, from incurring customer liability, the only way the Series B preferred holders can limit their exposure to customer contract claims is to argue for construction of the terms of use, a contract to which they are not party, that limits customers' contract liability claims to LLC. LLC is hopelessly insolvent. The net equity value of CNL, to the extent any exists in the global enterprise, arises from debtor and non-debtor entities other than LLC whose net equity value will flow up to CNL. Because unsecured customers recover ahead of equity holders under the absolute priority rule, the Series B preferred holders have some chance of recovery if customers hold claims only against LLC and not against CNL or other debtor and non-debtor affiliates. Both interpretations have undesirable practical consequences. A ruling that customers have contract claims against all debtors and affiliates could expose non-debtor affiliates to a customer liability because the terms of use do not distinguish between debtor and non-debtor affiliates. On the other hand, a ruling that customers have claims solely against LLC could deprive customers of whatever value would flow up to CNL from debtor and non-debtor affiliates. Notwithstanding the difficult consequences on both sides, the law provides the court with a clear process for interpreting contracts. First, the court is to determine whether the contract is ambiguous. Next, if the court determines the contract is ambiguous, the court can look to extrinsic evidence to determine the party's intent and, by extension, the proper interpretation of the contract. If, and only if, the extrinsic evidence does not provide the answer, can the court invoke the tiebreaker rule of contra proferentum, that the contract be construed against the drafter. In setting the briefing schedule for this matter, the court required the parties to provide the court with any extrinsic evidence they believe supports their respective interpretations of the terms of use. Therefore, the court concludes that the record is complete. As explained below, the court concludes, based on the record, that the contract is ambiguous. Considering the extrinsic evidence, the court finds, based on a preponderance of the evidence, that the parties to the terms of use intended that only the LLC and not any other debtor or non-debtor affiliates are liable to customers on contract claims under the terms of use. Because extrinsic evidence answers the question of the proper interpretation, the court need not and cannot invoke the doctrine of contra proferentum. Importantly, the court finds and concludes that the terms of use do not limit customers or the committee from asserting non-contract claims against CNL or against other debtor or non-debtor affiliates, such as claims for fraud, negligent misrepresentation, or other statutory or common law claims. In short, while the Series B preferred holders prevail here, they may very well end up recovering nothing. Nevertheless, The court appreciates that this decision may deprive customers of the full value of the company, but the court's obligation is to interpret the contract and evidence before it, and the evidence commands the court to accept the Series B preferred holders' argument that only LLC is liable to customers on contract claims.